T.D. Sood, the Law Secretary Shri P.K. Malhotra, the Vice President of the IT Shri D. Manmohan, distinguished Vice Presidents, members of the IT members of the bar, ladies and gentlemen. It's my privilege to be associated with the Platinum Jubilee celebrations of the IT. It's a coincidence that when 15 years ago, the 60th anniversary, the Diamond Jubilee was celebrated, then in my capacity as the Law Minister, I was even at that time associated with a similar function which was held to mark the 60 years of India's first and most premier tribunal. In one sense, the concept of tribunals was unknown originally in this country. Adjudication of rights is a judicial function. Interpretation of laws is a judicial function. And therefore the original concept was that all these matters really are to be decided by courts. But tax laws have some peculiar features. These are laws which are administered by tax officials. The first appeal is also an internal appeal which goes to the taxation department itself. And obviously, the manner in which fiscal laws are structured in this country and the dispute adjudication takes place after the assessment. One can legitimately argue that there is always an element of an institutional leaning, if not bias, in favor of the department. Taxation is indeed a very important sovereign activity. Governments run on revenue. And if revenue is inadequate, developmental activity of a society itself comes to a standstill. But at the same time, the tax laws are supposed to be very strictly construed. The normal principles of interpretation of any law involve several functions. Laws are interpreted with a purposive interpretation that you give effect to the purpose why the law was enacted. You give an interpretation which will avoid a mischief, which will avoid a violation. But all these general principles of interpretation of law has two exceptions. One is the taxation law and one is the criminal law. These are two branches of law where the simple principle is that it is the principle of strict interpretation which has to apply. In criminal law, either you have committed an offence or you have not committed an offence. Either your action falls within the parameters of an offence or it doesn't fall within the parameters of an offence. The law can't be stretched. Similarly, in a taxation law, you have to read the statute. And after you read the statute, Either a tax is payable or a tax is not payable. It's white or black. There are no areas of grey in a taxation law. And therefore laws are to be very strictly construed. And the simple principle of taxation is, even though taxation serves a very noble purpose, that it enables the state to carry on its welfare activities and developmental activities, a citizen cannot be unfairly taxed. So taxes which are payable are certainly payable, and taxes which are not payable can never be levied. Nobody can come up and say, well, on grounds of compassion, exempt or liberate me from the responsibility of paying taxes. There is no place for compassion. And at the same time, the plea that state needs more money and therefore taxation laws should be liberally construed in favor of the state is also not a plea which is available. And it is for this reason that those who framed laws at that time, and certainly it was a part of British India at that time that, and British were well known always for their commitment to the rule of law and for creating institutional mechanisms, that in 1941, the first tribunal of its kind in India was created. And a very distinguished jurist was chosen to be the president of the tribunal at that time, Justice Moni, whose name is repeatedly being mentioned. He is always referred to as a gentleman who later became the Chief Justice of Pakistan. But if I remember correctly, his most legendary contribution is his voluminous work on the law of evidence. And any law library would always have Munir's law of evidence. And I'm sure somebody now must be continuing to re-edit that monumental work that he did. And this tribunal, therefore, in 1941 became the mother of all tribunals. It was the first tribunal. Its success or failure would determine whether tribunals have to be created with regard to other areas of specialization or not. And the structure of this tribunal also was to take expertise from two different branches. You had a judicially trained mind who would be keen to interpret the law, and you would have a person with an experience of taxation. So it was a cocktail mix of two different specializations which made up for this tribunal. And since then, 75 years is a long period. It is this combination which has decided tax cases in abundance. There is an advantage in creating tribunals, and the advantage is that instead of being a general expert subject, you have people whose core competence is taxation. So the judicial members also, with years and years of experience, become experts in the field of taxation, particularly direct tax, since the IT deals only with the Income Tax Act. And of course, you have the tax officials who know the complicated act backwards. so that they can also become experts in this subject. And the advantage of having an expert tribunal is that people are familiar with judgments, people are familiar with precedents, people are familiar with the legal principles on which cases are to be decided. And this expertise itself can lead to an expeditious disposal. The IT is an important forum for the reason that it is the first opportunity that an assessee gets outside the structure of the department in order to agitate his case. And therefore, this first opportunity outside the department is an extremely important opportunity. It must be a very fair opportunity. A person should be heard at length. Because after this opportunity, the remedy before a High Court or a special leave petition before a Supreme Court is a limited remedy. It may essentially be available on very complex and complicated questions of law. Matters of fact simpliciter may not be capable of being agitated before those forums. And therefore the tribunal has to have various features. Its members have to be experts. Their core competence of specialization has to be the direct tax law. They have to dispose it of expeditiously and yet give a fair hearing. And dealing with money and money matters alone, they have to be free from all forms of temptation and have to lay down the highest standards of personal ethics. It's only then that a tribunal gets a reputation for its integrity, for its specialization, for its competence. And therefore, orders passed by it are therefore capable of being well regarded. And that is one reason why even judgments decided by the Income Tax Appellate Tribunal, which otherwise may be an authority below the High Court. Normally it's the High Court judgments which are important. But outstanding judgments of the IT are also referred to as good precedents, are published in your journals, are reported very well, are cited repeatedly as precedent. And if you look back the last 75 years, it's a tribunal which has stood the test of time. And it has led to a further experiment of creation of other tribunals. Now it's become a jargon to say that is there an excessive tribunalization of justice which is taking place? Courts are overcrowded. Courts are packed with cases. India's population is very large. And by temperament, we are a set of litigious people. And being litigious, we litigate even on cases where we don't have a strong difference. And one illustration is, after all, what are cases of the Negotiable Instruments Act, cases of bounced checks? What are cases of bank claims? Obviously, monies are payable, even then people litigate. Insurance companies, after insuring individuals or insuring against certain events or contingencies, when claims arises, why do victims of motor accident claims have to go to courts or tribunals? These are claims which should be instantaneously honored. The quantum itself may be a matter of dispute. But being litigious people, we are position to dispose of all these cases. And then courts have a particular challenge, as the Law Secretary mentioned. They are bound by various procedural constraints. And if I may be pardoned for saying, even where time periods are prescribed, courts are not bound to adhere to those times. Courts frequently stricture governments when governments don't decide expeditiously. But when laws mention time frame for courts, they always interpret it to say this time frame is directory and not mandatory on us. So the rest of the society is bound by time constraints, courts are not. And one of the reasons is that courts have to follow procedures. They have to follow the criminal procedure court, they have to follow the civil procedure court. Arguments are lengthy. At times arguments are verbose. Nowhere in the world is unlimited time given to argue a case. Time is fixed. I remember, if you have witnessed courts in other parts of the world, whether it's the US or England, the time period allowed for oral arguments is to be strictly followed. But in India, I think like political speeches, court arguments can also go on for a reasonably long period. We suffer from the same problem in Parliament. We are never able to adhere to the time period of the debate. Because once you get a mic, you enjoy speaking. I have always believed that it's great fun to deliver a speech. It's a different matter that it's very painful at times to listen to them. Because when people go on and on, it can become monotonous, but that's a part of our democracy. And it is for this reason that to liberate some specialized areas from the procedural laws, to just allow them to follow a fair procedure, what the Law Secretary said, principles of natural justice. Here both sides. So freedom from procedural laws, specialization in a subject, expedition, and faster disposal. And core competence in that area. I think these are the rationales. And it is for this reason that quasi-judicial institutions have been created. Now, another idea was to ensure that the courts don't get choked because of this excessive large case population in the country. Some tribunals have succeeded, some have not succeeded to such an extent. But I don't think there is an alternative option that you have. And therefore, the experiment has been repeated from wherever specialized institutions have been created. I think one of the challenges before every institution is to continue to reform and improve. And I'm sure the IT will also continue to perform its functions. The President, Mr. Justice Sood, I must incidentally confess had the privilege of knowing him for a very long time, from the days when he was in the bar. And he mentioned how they are trying to sort out the issue of arrears itself. I hope, Justice Sood, you and your colleagues do succeed in solving that problem. But one fact is apparent, that the number of assessees in this country is not going to come down. As the economy expands, more and more people come into the tax net. And when more and more people come into the tax net, there will be obviously more assessees. In fact, one of the points of serious analysis is that compared to our population of 1.2 billion, are we a society which has too few assessees? So even though academically this point is addressed, but actually if we see, our social structure is such that barring some very few people or very few families where the ladies are working, gainfully employed, and there are multiple assessees, a large number of families in our social structure will have only one assessee. You have about a significant section of our population below the poverty line. So obviously you can't find assessees there. You have 55% of the people involved in agriculture, an activity which is exempted from income tax. And therefore another major chunk goes out. So if you exclude the people below the poverty line, if you exclude the people involved in agriculture, and then count the residuary number of families in India, and India has about 24 crore odd families, the number becomes quite restrictive. And therefore we have to gain headway or headspace from the number of people today paying tax who are assessed to income tax and the headspace available after excluding these two categories. But one basic feature is that the laws must be simple. So even if you have a large number of assessees and you have a large case population, if your laws are simple, then the possibility of excessive litigation itself doesn't arise. And one of the reasons in our complication is not merely the accounting of how much who earns and what are the kinds of deductions that he claims. If you look at the actual functioning of the department, less than 1% of the cases come up for scrutiny. And for the determination of that scrutiny, there is no human interaction. It is selected on basis of indicators fed into the software system, into the monitoring system. And if the returns indicate that one of those alerts comes up, it's only those limited cases which are selected for that purpose. But then, since we amend the Income Tax Act every year through the Finance Act, the Act itself has become very complicated in drafting. So there is a group under Justice Ishwar which is looking into the whole question of cleaning up the Act itself. The Som Committee report also has given several recommendations which we are at a very advanced stage looking into, which administratively have suggested certain reforms reforms in the tax administration itself. In recent months and years, we've taken a large number of steps. For instance, we've decided that which are the categories. So any case where the tax effect is up to 10 lakhs, one need not go to the tribunal. If it is up to less than 20 lakhs, one need not go to the High Court. So the number of appeals are being restricted. And I think IT has a very important role now in tax assessments. So more and more returns are now online. The queries are being addressed online. The answers can come online. I think most people, and that has helped in eliminating a large part of the corruption also, that tax refunds have also gone online. So the intimation of tax refunds is online, the receipt is substantially now subsequent to that. And therefore the human interaction in those assessments itself is coming down. And if judgments are strictly adhered to, and in order to adhere to the judgments, the assessment of the officials in the tax department has to be linked to the quality of their performance and not to the targets. That is one of the instructions which has been issued. And therefore, if judgments are adhered to and the laws are simple, in fact, one of the proposals I announced in the budget last year was, since corporate tax assessments are a very complicated area, that if we look at our tax structure, ostensibly India has one of the highest corporate taxes compared to comparable economies. So with 30% you can add the surcharge and make it 34% plus. And if you add the distribution, dividend distribution tax to it, so investors all over the world, when they see comparative economies and they sum total this, they'd like to invest in those jurisdictions where tax rates are more reasonable. So as against the rate of 30 plus surcharge, which is 34%, the actual recovery is a little over 22%. Because everybody has a large number of exemptions to claim, particularly on the corporate side. I'm not referring to individual tax in savings-linked investments. So on an optical view, it is 34%. In an actual view, it is less than 23% collection. So we have an image of a high taxing nation, but our recoveries are of a low taxing nation. And that is one of the reasons that I announced that it is better to have a lower rate and phase out exemptions and have a cleaner, neater tax system. So a neater and a cleaner tax system, which is easy to look at and interpret, where tax returns are simple, hopefully the judgments are clearly adhered to. Human interaction is the least. Scrutiny cases are the most minimal. And therefore the regime itself can become easier. And an image of an oppressive taxman doesn't hover over us. And once we have a simpler tax system, hopefully there will be lesser appeals. And while you and your members will continue your effort to bring the arrears down, we'll continue to make the laws simpler so that fewer appeals are also filed and issues can be resolved by easier assessment orders itself. It's only then that we have a tax system which is of greater friendliness to the system itself. I do hope that with all these changes and an improved performance in the tribunal which you are endeavoring to get, the arrears will be low, our tax buoyancies will be higher, and the harassment to the assessee would probably be Platinum Jubilee celebrations, it will be a great opportunity for the tax administration in India. My best wishes to the Income Tax Appellate Tribunal. As you look forward to your centenary celebrations 25 years down, and I'm sure each year will add to the competence and maturity of the Income Tax Appellate Tribunal. Thank you very much, Justice Su.